Good afternoon and welcome to today's presentation, the ISO Safety Risk Assessment Defense. In today's webinar, Mr. Mangold will discuss definitions of ISO, OSHA, and risk assessment, analysis of the Cameco versus State of Ohio VSSR decision, plaintiff's counsel strategies, and defense counsel's consideration. To give you a little background about our presenter, Vernon Mangold, he is currently the Vice Chairman of the AWSD 16 Robot and Automatic Welding Committee. He currently serves as founder and principal consultant for K Safety, an engineering firm. Mr. Mangold is the former president and CEO of Cohol Systems. He has worked as an expert witness since 1984 and has 40 years of advanced automotive industry experience. For those of our attendees who require a passcode, the word for today is ISO. During the Q&A session, we'll ask that you enter this passcode into the Q&A widget for CLE reporting purposes. The Q&A is located to the left of your screen. Please remember that if you're applying for CLE credit, you must log onto your computer as yourself and stay for the full 60 minutes. We are also required to complete the survey at the end of the presentation. Tomorrow morning, we will send out an email with a link to the archive recording of the webinar. The slides can be downloaded from the resource list on the left of your screen. Thank you all again for attending today, and Vernon, the presentation is now turned over to you.
Thank you, Emily. Let me begin by saying the obvious, but it needs to be stated. I am not a lawyer, and I'm not legally trained, and I'm not licensed to practice law in any state or jurisdiction. My comments today are technical in nature, and they're based upon my 40-year experience in the automated systems business as a tool and die designer, computer programmer, manufacturing company owner, and as a consultant. So my opinions are technical in nature and should not be construed as legal opinions. First, let's talk about what we want to do for scope, okay? So everyone has the proper context for this. This webinar is designed to provide practical information and support for lawyers and for people who are involved in industrial safety. So the focus here is on OSHA 300 lost time industrial injury accidents. If it's something other than a 300 reportable injury, it's not necessarily in the scope of today's webinar. We'll talk about the definitions of consensus safety standards, what they are and how they work, the current conflict between ISO and OSHA over matters of particularly robot and automation safety. We'll talk about a specific case that actually went to a decision in a court of Ohio, and that is the Cameco case. And what I must explain is that the Cameco case is a VSSR claim action. We'll talk more about that later. But it was not the underlying case. The underlying case, like so many cases in safety, settled out of court. The case study review, Cameco versus State of Ohio, will be discussed. And then we'll talk, generally speaking, which is really the format for this webinar, plaintiff's counsel strategies in these type of cases, and important information for defense counsel to be considered. And then we'll talk about the value of human life in ISO factories on a worldwide basis, as opposed to the value of human life in U.S. factories. Now, let's begin with the ISO-OSHA conflict, okay? And for those who are not familiar with the robot industry, and I'm sure we have a lot of lawyers here that are scratching their head, this is not only just about robots, but the centerpiece of this case involves robots and automation, but all future manner of servo-controlled technology, particularly the latest advances in RF technology. On the left-hand side of the slide, you'll see we have the current robot technology and the requirements in this country. You'll hear me say that repeatedly today. I'm talking about this country. That should not be confused with the rest of the world. The rest of the world views the matter of industrial safety entirely different from the way the U.S. views it. Okay. Now, future robot technology is the presence of people within restricted zones with no physical barriers, and a concept that is really taken on hold in Europe, but is not functional here in this country, and that is allowable incidental cutting and bruising. We'll come back to that later. And then workers interacting directly with equipment in some form of automatic mode. For those of us who have been in safety for all of our adult life, that's a pretty big step, because we've always said people are not to be in the restricted zone of robots or automation during any type of automatic mode. And then one thing that the folks from ISO have really no concept for is LOTO, as we abbreviate it, lockout, tagout. The formal name for this OSHA requirement is the control of hazardous energy. And what is an industry voluntary consensus standard? There's a lot of confusion on this, and what I will also say, since everybody on the webinar is going to get copies of the slides, I'm not going to spend a lot of time in reading slides and just talk generally about what the slide imparts. An industry voluntary consensus standard is as the name implies. Although they look very official, they look like legal documents, they look like regulations, they are voluntary in nature. And they're produced by NGOs, which is a non-government organization of some type. And of course, the best of these have procedures and rules, but at the same time, in this country, in the United States, the only regulations that have the rule of law are those produced by OSHA or state equivalent organizations, or in some cases, local jurisdictions that then work in concert with OSHA. So a voluntary standard is as the name says. You don't have to do it. It is voluntary. Now, the two leading NGOs who are responsible for industry consensus standards here in the United States is the American National Standards Institute and International Standards Organization, ANSI and ISO. ANSI is based in this country with offices in New York and Washington, D.C. ISO is based in Europe, in Geneva, with other offices around the world. You can read this text for yourself. What I did is simply copy the mission statement of both organizations. It has been for some time a course of action in American industry to refer to ANSI standards for virtually all aspects of industrial safety. Although ISO standards are becoming more in the vogue and use in the United States, that's a more recent development. And ANSI has been the leader historically, particularly in the robot industry, beginning with some of the first robot safety standards, which were, of course, ANSI standards. Now, I've already generally speaking to the difference between OSHA and ISO. Excuse me. OSHA, again, is a department of the federal government of the United States. Although they talk about their regulations as standards, and you'll see in the literature and you'll read and say, oh, standards. They use that term interchangeably with regulations, but the reality is OSHA requirements carry with them the force of law. They are not voluntary. They are subject to penalties that one would find with any law. OSHA, the Occupational Safety and Health Administration, is part of the Department of Labor of the U.S. federal government. And in reality, there are over 30 states that have a equivalent parallel state organization. ISO characteristics. ISO is also industry voluntary in nature, and in many countries, ISO standards are supplemental to what is called home rule standards. For instance, France, Germany, UK, Japan, a host of other ISO countries also have home standards. So they have ISO standards and they have their own home standards, which vary depending upon the industry and the application. Now, generally speaking, ISO standards are written in the consideration of a rather European-style legal system. And that's important in today's discussion because in the United States, uniquely, the first line of responsibility in the event of an injury accident is with the employer. That's not true in the rest of the world. It's not true in the rest of the ISO world. And if there is an injury accident, and if an injured party wants to bring a claim, again, generally speaking, the U.S. form of law with adversarial trial by jury proceedings and so forth are not followed. And, of course, there's also the loser pays paradigm, which would imply that for the average victim, they have a very little chance of bringing any type of claim in any industry accident. And in the event in certain countries that the victim is able to bring a claim and get it into a court proceeding, it's typically not a trial by jury proceeding as we know here in the States, but rather it is a trial by magistrate or by local expert. And those experts are typically professors at the local state-owned universities. So as a consequence of that, again, the victim has usually little opportunity for any relief in any claim. Now, some of the fundamental things in the CFR code that OSHA uses for their regulations that stand out as not being recognized by ISO are listed on this slide. First is the ubiquitous term lockout tagout. And by the way, I see this expressed numerous times as LOTTO, like a state lottery. No, it's LOTO. It's LOTO. OSHA has a lot of regulations that pertain to hardwired emergency stop controls, as it's provided in NFPA 70 and 79. The concept of single point of control, which is extremely important. RF-controlled safety devices are not generally considered acceptable under OSHA. And I say that in the context of the further discussion we're going to have. And in everything you read under OSHA in the regulations, not necessarily training guides or other supplemental materials, but in the actual regulations, is based on physical barrier guarding being preferred, and it is so stated in the regulations. Now, let's take a look for a second at current modern manufacturing. And that's why this information is not just appropriate for robots and automation systems, but all manner of computerized devices, presses, cleaners, washers, any type of process equipment, and process technology, foundry, welding, etc. Make use of advanced computer technology, of course. But current facts, the U.S. still maintains its leadership position in total manufacturing GDP. I realize when you do the numbers, you can always gin the numbers, and the Chinese are right there, nip and tuck. But the U.S. continues to outgross all other countries. And the key point, item 3, and this is something that should resonate in today's discussion, especially from a legal perspective, the U.S. remains the safest industrial country in the world, both in per capita terms and absolute measurement. In my estimation, what that says is the U.S. must be doing something right. This item has been debated numerous times, and I found no evidence internationally to come to any other conclusion. We are safer. And the biggest reason that we're safer is that we practice defensive engineering in the United States. And there are people that will disagree with that process, but the facts speak for themselves. The U.S. remains the safest industrial country in the world, both in per capita terms and absolute measurement, and that's not too bad. Now, I want to take a moment to talk about a purely technical aspect of today's presentation, and that is another ubiquitous term within robots and automation, and that is the teach pendant. Now, teach pendants began life, as we know them, in the robot industry, but a lot of other machinery, CNC machines, process equipment, advanced conveyor systems, etc., have similar devices. So it's not just a pendant strictly for robots, although that's where they got their start. And in keeping with today's discussion, the Cameco case involves teach pendant. So I thought it would be important to just talk about the basics. What you have here on the screen is a, let's call it a generic teach pendant. And you can take a look at some of the features that I've got listed here. The device is a teaching device. It is a troubleshooting device. It's also important for programming. And the final point is it also doubles as a personal protective equipment device for personal safety. So it's a safety device as well as a technical engineering type device. It serves both roles. So when I speak today of teach pendants, that's generally speaking the device that I'm talking about, the device you see in the picture on the screen now. Now, the Cameco decision. We talked about that originally, and I will not go through the detail of these slides, but I'll talk generally about why the Cameco decision is so significant. As Emily mentioned in my opening bio, I started in this industry in 1975 as a tool and die designer working on special automation systems. So if you do the calendar, I've been doing this for 40 years. And in that time, it's impossible to do this business and not on occasion to come into contact with the legal system. It's just the nature of manufacturing. But in that entire time, never have I ever been involved in any legal case that actually went to verdict, went to decision, or went to an actual trial verdict. It just doesn't happen. As I'm sure most of you are aware, these type of cases settle out of court. In fact, in the last 10 years that I've been working full-time as an expert witness, I've had 2 different cases that a jury was seated, but the case settled in the hallway. So that's what makes this so significant. Here is a point of confusion that must be clarified right now. As some of you have emailed me already before this to tell me that, well, this is a VSSR case. Now, a VSSR case is a claim for benefits for a victim. I don't know that it is specifically only in the state of Ohio. I know it's an Ohio phenomenon. I'm sure other states have equivalent type of measures to provide victims with additional relief. The whole idea of this is that the victim cannot bring an intentional tort in the state of Ohio, but rather they get a supplemental benefit via the VSSR. That acronym stands for a violation of specific safety requirement. In Ohio, that's under revised code 4101.11. Now, because these cases never go to trial, because of that, okay, a lot of the underlying facts are never in the public domain. Insurance companies write the last check, and then everybody moves on. In this case, however, the underlying case settled as it normally does. In this case, the employer made a settlement. The equipment supplier, in this case Wayne Trails, made a settlement, and everything moves on. However, when the victim came back to apply for a VSSR, Cameco, his employer, objected to the VSSR claim, and they appealed that VSSR claim 3 times at the administrative level, and then eventually took it to the appeals court in the state of Ohio. I was hired by the state of Ohio in June of 2014 to help present the state's case. The matter went to court in July of last year, and the decision was handed down in December 2nd. To the best of my research, it's the only case of its type to handle the kind of issues that we're talking about today that actually went to a verdict. It went to an actual decision. And that's significant because now the lessons that are learned from this case can now be discussed more openly. There's a certain amount of propriety that you'll see today. For instance, those people who were deposed, who are witnesses in the case, I'm not going to mention them by name necessarily, unless they're already named parties. But the importance is what happened to the victim, what was the circumstances, and what lessons can we draw from that. Again, the decision was rendered on December 2nd, 2014 in the 10th Appellate District. I believe, and this is something that Emily can address separately, I believe that we can get a full copy of that decision. I suspect it's part of the materials that Emily will be providing. But again, it is an appeals decision. And I have to stress that appellate decisions are somewhat tedious and difficult to read. Not for the lawyers we have online, I'm sure. But it's an appeals decision. So consequently, there's a tremendous amount of background information. There's a history, as it were, of appeals and claims and so forth. It seems like it meanders rather loosely until it finally gets to a point. But the point here is pretty obvious, okay? It's obvious when you read that and the depositions and the expert reports. One of the things that comes from having a decision is now the depositions, the expert reports, and so forth are now in the public domain. The answer is simply this. The night Mr. Albu suffered his injury, it had nothing to do with safety fence violation or anything to do with any type of risk associated with normal production use, but rather had everything to do with a misapplication and a non-compliance with a very specific safety requirement, and that is OSHA 1910.147, the LOTO standard that we just discussed. That was the proximate cause of Mr. Albu's injury. That's what's important. Now, the timing of this decision is rather dramatic because there's been a major change in safety standards for automation in this country. In 1999, ANSI approved the RIA R1506 document, designated as the 1999 standard, which included prescriptive measures for safeguard selection and also included a qualitative matrix-style risk assessment process. But most significantly in that document, included in the normative references, were the OSHA regulations that we previously discussed. So the document was very comprehensive, and it really took care of the needs of quite a few stakeholders. But all that's changed now as of June of 2012 and codified in April of 2014 when the RIA chose to approach ANSI, and ANSI approved the adoption of the ISO 10218 safety standard, as they say in the business, whole cloth. By taking it whole cloth, of course, that eliminates all the very specific U.S. requirements, most notably the normative references for OSHA, lockout, tagout, and a host of other things we've discussed. That's why this timing is so critical. The new standard, the adopted ISO 10218, has not been in the field long enough to even get any feedback yet, but it's coming, and it's important from a legal perspective to understand what the significance of that standard is. At this point, we're going to go to questions at a break. As you probably looked ahead of the slides, we have the legal blocking and tackling after we conclude the question session. Thank you.
Okay, and could all the attendees please type the passcode into the Q&A? Our first question is, why is there no U.S. legal requirement for industry voluntary consensus standards?
And Emily, I guess the format, I'll just take these questions as they come.
Yes, I'll be reading them out to you.
Excellent. But to answer the first question, there's no legal authority, primarily because, not only because it's historical, but beginning with the William Steiger Act in 1970 and the creation of OSHA, it was decided at a federal level and then codified by the states that matters of legality in terms of regulations would be handled at the federal level. Again, it's just the unique nature of our legal system. There is no legal requirement, and actually that would be a ponderous task to do that because there's a host of different NGOs and standards and so forth. In this country, in fact, the American Welding Society has a robot safety standard. UL has, Underwriter Laboratories, I should spell that out, has a robot safety standard. So to be able to take this and make it as a matter of law is really cumbersome and I think decided generally as unwieldy. But that's our country. In our country, that's the way it is. The federal law then begats state law, but it's only in that arena. The voluntary standards are strictly that, voluntary.
Okay, and do you think there will be a legal U.S. requirement in the future?
I'm not a lawyer, and I don't presume to practice law, and I don't know how much longer I'm going to live, but I would think in my lifetime it's not going to happen. There's no groundswell of interest in doing that. And at the same time, when you take a look at the legal requirements, there is always a need for uniformity, especially uniformity that crosses state line. I think that's the biggest driver behind the 1970 Act, was that there was a need that came from the grassroots to say, we got 50 states and other jurisdictions, let's try to cut through these barriers and let's have a federal standard. I think the thinking was good, generally speaking. Not everybody's going to agree with having the federal government dictate safety from a global perspective, but that is our system, that is the way it is, and I would imagine, at least in my lifetime, we're not going to see any change in that.
Okay, we're going to take questions again at the end of the presentation, so please continue on.
Thank you. All right, now let's talk about Mr. Albu and his accident. That's what's so unique about this decision. I've worked on 16 similar cases over the last 20 years. This one I can speak to more specifically because, again, it went to a decision. Let's talk about the people involved. Cameco Lorraine is a manufacturing company located in Lorain, Ohio, a western suburb of Cleveland. Wayne Trail is a company located in Fort Laramie, an equipment manufacturer, robots and automation system, and they're now a wholly owned subsidiary of the Lincoln Electric Company. Yes, Motoman is a robot manufacturer located in Dayton, Ohio. Home company is Yaskawa, based in Japan. And what's interesting about this case is that although it involves a Motoman robot and a Motoman teach pendant, the Motoman robot really had no active role in the accident. Now, we'll talk about this in more detail, but generally speaking, Mr. Albu was doing a service event on a system that Wayne Trail described as the flex bender system, a fully integrated automatic system with servo bending equipment, with presses, with welding apparatus, a complete manufacturing work cell for the production of a family of different seat components. Now, it's generally described among the other experts as steel pipes. I prefer to say they're steel tubes, but the tubes are bent, dimpled, and otherwise processed through the system. The role of the Motoman robot in this case is a material handling function, moving tubes from one machine to another. And the night of Mr. Albu's accident, he was in the process of clearing a jam, which is not a legal term per se, but the machine stopped running, as it did routinely, because of some type of problem with the production. Either the part was out of adjustment, either the die was out of adjustment, the heat of the steel was different, the spring back of the part was different, whatever the reason might be. Alarm went off, Albu went into action to do his job. At that point, Mr. Albu did something that he had seen other maintenance people do, and also Wayne Trail people do, and that is bypass the perimeter safeguarded area and go into the work cell to do his function. Now, unfortunately, in the analysis of this, the experts for Cameco and for Wayne both assumed that Mr. Albu's injury happened because he bypassed the safety fence. Well, one of the things that came out of the decision by the court was that it affirmed the fact that Mr. Albu's accident had nothing to do with safety fence. It never did have anything to do with safety fence. In fact, if this was a plant in Japan or China or other parts of the world where they don't use safety fence, they simply paint lines on the floor, if there was no safety fence at all, Mr. Albu's accident would have happened anyway. The problem here, and again in this country, is that Mr. Albu was performing a service function. He had the Motoman robot in the teach mode, and in teach mode, that means slow speed control. And under slow speed control, he has single point of control of the robot arm. Now, as you'll come to find out, there's hazards that are associated with being hit by the robot arm. But in all my research, in all my years of doing this, rarely does a robot arm strike anybody. Serious injuries occur because of other problems, most notably interference with other machinery, other processes. That was true that night. Mr. Albu had the Motoman teach pendant in hand. He had it in teach mode. He was examining the clamping process of the tube, cycling the clamps back and forth, did it to clamp, to unclamp, the troubleshooting process that he was taught to do. What happened succinctly was that he pressed the wrong button and enabled the wrong output. Instantly, as soon as he saw the clamps not move the way that he thought they would, and he heard a funny noise, instinctively knew something wrong. He mashed the E-stop and dropped the teach pendant, doing two things. Once you mash the E-stop, the presumption that you have in industry is that when you hit an E-stop, everything goes to a zero energy state. Everything goes to a crash halt. That's the first thing. And because teach pendants are equipped with a mid-position switch, that too should have stopped all hazardous motion associated with the robot. So he did two things. When he hit the wrong button and forced the wrong output, something happened in front of him that he did not expect. So instinctively, he mashed the E-stop button and dropped the teach pendant. But he was struck anyway. Another machine, we'll call it the extractor, which is a custom servo-controlled machine built by Wayne Trail, hit him from behind. That machine had no active role in the process that he was doing the troubleshooting for, which is why he probably ignored it. But that machine was still live. That machine was operating under the PLC control, which is a PLC is a computer system built by Wayne Trail to manage the system. And when Mr. Albo unwittingly hit the wrong button. He caused a sequence of events to occur in the PLC, which gave a signal to the extractor, which was not locked out. It was not tagged out, that struck him. So this accident would have happened regardless of safety fence, light curtains, or any other secondary safety devices. And for a parallel, I know the obvious point is going to be raised, well, you know, this guy, it's his fault. He hit the wrong button. Yes, and all of us that have been in this business a long time, if we were honest, would talk about our near-miss conditions. My last near-miss myself was in 2006. But at the same time, this is why lawnmowers have kill switches. It is unlikely or uncommon that you're ever going to get your hand under a mower while the motor's running. However, if by some chance that does happen, the results are pretty obvious and immediate. If it's running, you're going to lose part of your arm. The same basic general theory applies here. That machine should have been locked out and tagged out in accordance with a strict read of 1910-147. And that's not just 147, the main regulation, but also the alternative. It's a very long and very complicated regulation, but it speaks to the fact that any service event that involves machinery in the same restricted area that has nothing to do with the service event in question must be locked out and tagged out appropriately to make sure that an accident like Mr. Albu's does not occur. Now, I know people have taken issue with my terminology here, blood on the teach pendant, but the only thing I was able to share with the American Welding Society and RIA and other organizations when I first was brought onto this case in 2009 was a most unique photo. This photo is the actual teach pendant that Mr. Albu had in his hands at the time of the accident. And it's the Motorman Robot Teach Pendant. And I find this significant because there happened to be a Bureau of Workmen's Compensation operative in the Cameco plant the night that this accident occurred, just by happenstance. He was there recording a different problem, a different situation. But he heard the alarms and he heard all the commotion and came running over to the accident site shortly after Mr. Albu was struck. And because it's a state-owned camera that he had, and because he's a state employee, he took a picture here, and this picture was taken shortly after Mr. Albu was removed. He took this picture, and I did a Freedom of Information Act request and was able to get this picture. Because normally, this type of evidence never sees the light of day. But in this unique situation, just by happenstance, just because the guy happened to be there, we were able to capture this particular photo. But it speaks to the issue here. The man was doing as he was trained to do. He was doing as he's done before. He had a teach pendant, and the presumption was the teach pendant would keep him safe. And that's a very logical presumption on the part of a maintenance worker. I have a teach pendant, I've got a mid-position switch, I've got an e-stop, I should be safe. But that particular night, those safeguards did not keep him safe. And that's why I've referred to this as blood on the teach pendant, only to drive home the point that sometimes you get a false sense of security. You have these devices, but the underlying logic is not correct. And the design process is somewhat feeble. People can still get hurt even though they have a proper teach pendant in hand. Now, some facts here. And this is now we begin to talk more about the legal strategies. At the bottom of this graphic, you'll notice the OSHA regulations that are routinely in the top 5 cited by OSHA every year. And I say top 5. I think there's like 375 different regulations that get cited. I mean, there's a lot of them. In the top 5 are 1910-147, the control of hazardous energy, and 1910-212, which is the general requirement for machinery guarding. And these are important because in our legal system, I say our, I'm saying the U.S. legal system, okay, when OSHA comes in to investigate, they're going to follow their regulations. Now, they use industry consensus standards for advice and consent, for information, supplemental in nature to an accident. At the end of the day, for those of you who have seen an OSHA citation, at the top half of the citation you were cited only on public law violations, and that is from the FARs. And typically, in almost every case, 147 and 212 are cited because those are the two most frequently violated of the regulations. Now, what's significant here is that production workers rarely, if ever, sustain a serious injury accident event. It's typically non-production people, maintenance, setup, engineers, managers, other folks. In fact, by my research that I've conducted over the past 20 plus years, it's well over 60%. We take good care of production workers with the appropriate safeguards. It's the other people that sometimes we have a problem with. Now, 1910-147 and 19-212 are not recognized, of course, by ISO. So therefore, if you have safety standards that are in use in this country and they ignore the specific requirements of OSHA, then it's somewhat of a buyer beware situation. And of course, those that manufacture products in the States need to be aware of that. Now, let's talk blocking and tackling. Now, let's talk about administrative practices. We're in that part of the presentation. And I'm directing this right at plaintiff's counsel, for starters. What do? You're handed this case, and you need to sort out your discovery process. What's the first thing you do? Well, the very first thing you do, after you identify the defendants and all that sort of thing, you ask one foundational formative question. Did you or anyone else at your company create a formal ISO risk assessment for the equipment that was involved in the injury accident event? Simple. Find out if an ISO risk assessment, the formal version of the risk assessment, exists. And when you ask that question, either in direct examination or in deposition, there's only three possible answers, of course. Yes, no, and I don't know. I'll leave the I don't know answer to the attorneys because I'm sure attorneys know how to make the arguments in that perspective. But there's yes and no. Yes, I did do an ISO risk assessment by some formal means, or no, I didn't. That leads to the next part of the process. But it's a standard question that should appear early and, in many cases, often in the discovery process. Did you create a formal ISO risk assessment? Now, let's take a look. Well, let's take a look at doing the right follow-on questions. Right? Now, if the answer to the question is yes, now, from a legal perspective, you can force the defense to defend their risk assessment. And that's not an easy thing to do because the ISO risk assessment process is qualitative in nature. It is akin to a guessing game on probabilities. And these are probabilities that largely are not the type of probabilities that engineers normally encounter every day in their work. And interestingly enough, in the robot business, there are three principal characteristics that are analyzed. And those three are shown at the bottom of the slide. First is the exposure to the hazard. The second is the ability of the worker to avoid the hazard. And the third is the anticipated severity of the potential injury. And let me be very, very clear on this subject. If an accident occurs in a plant, if it requires OSHA to investigate, and if OSHA goes into the plant and cites the employer on any of the FARs, 1910, 147, 212, 132, 136, 145, any of the most popular ones, then the employer has the opportunity to contest that citation. But I'm speaking here to the attorneys. Typically, the advice from the defense counsel is don't fight OSHA. Settle up, bargain down your fine as low as you can get it, and get out. Now, that said, as soon as you tell OSHA, well, I'm not admitting guilt, but I will pay the fine. I just want to pay a smaller fine. Even though it's not an admission of any guilt, in third-party litigation, again, I'm not an attorney, I'm speaking just from a technical perspective, but now you've given plaintiff's counsel all the ammunition in the world to bring suit because you have tacitly admitted that, yeah, we had a problem. So From that standpoint, now you proceed to the next step. When you have to defend your risk assessment, because there's a probability, a man got hurt on the job, okay? So now we start to dive into the engineer's mentality of exposure to the hazard, which, by the way, under ISO, it's backwards. ISO typically views exposure different from what statistics show. The ISO approach is that those with the highest level of exposure to the hazard are most likely to be injured. The reality is just the opposite of that. But regardless, the next one's a little tougher to state. Avoid the hazard. And the last is the anticipated severity of the potential injury. If you chose safeguards and you did not take into account the severity of an injury that resulted into a 300 lost time situation, then you're wrong. So those are the three main characteristics. What I have included here is just one example of a qualitative risk assessment matrix. You'll notice the three characteristics I described before. You'll notice the far right-hand bar where we talk about the rating, whether that particular risk is negligible, low, medium, or high. And you can see how this moves from left to right across the page. Well, this is a qualitative approach, and it's based upon the analysis of the individual creating the risk assessment. So as a consequence of that, it really doesn't matter what it says on the far right-hand bar. A worker got hurt, and there's only two circumstances where this does not apply. One is an overt act of God, or two is a malicious act on the part of somebody to use a robot system as a weapon. That's the only two occasions. The only two. One is a bolt of lightning or some other act of God that caused the accident. Or some criminal deviant mind decides to tell somebody to stand right in front of the machine so that they can hurt them. In every other case, the guy who did the risk assessment is wrong. And under the ISO system, he's personally wrong. Not just wrong for the company or wrong for the insurance company or had a bad day. He is personally wrong. That changes the game dramatically. It's at this point in the discussion, in the cases I've worked on, I've sat in the deposition rooms, I watched the attorneys for the insurance companies become very, very nervous. The last thing they want to do, and again, I'm not speaking as an attorney, but having attended a few trials myself and I've watched the process, you don't want to put in front of the jury an engineer who cannot explain the reason why he was wrong. That's a very painful process. And it's about at that time that the insurance companies decide to settle. Now, this is one version of the matrix. There are a variety of different versions of this same basic matrix, but I took the most simplified version I could think of to provide you with a model. But now, you're plaintiff's counsel, and you got the defense back on their heels. They now have to defend. If they knew what they were doing, if they were really good at this qualitative risk assessment, how did the guy get hurt? That's a very logical question to ask. Now, this is what the recommended ISO form looks like. All the information at the top is all pretty much common and standard. But the part that should give a lot of engineers pause is right below the company, robot cell, and robot manufacturer, and that is approved by. This is where in the ISO system you're required to be compliant with the voluntary standard to personally sign. Who is that person? Is he an industrial engineer? Is he a manufacturing engineer? A manager, perhaps? But it's somebody. In other words, you did this analysis and you signed it. Now, and again, I don't practice law, but based upon personal experience, I can tell you that at this point in time, you now are a named defendant. You are in the crosshairs because this was your assessment and a man got hurt. So now you have to defend why you chose what you chose. And according to OSHA, if it's a violation, particularly of 1910-147, it could have been avoided because what OSHA has said, and you've agreed to because you paid the fine, is that you agreed that things weren't locked out. Well, now how can you explain away why you didn't lock it out? Let me give you a not so closely guarded secret. I have not encountered a client yet that pays enough attention until such time they've had a serious accident, of course, the OSHA regs, particularly lockout tagout. Because, and this is a good question to ask yourself in this webinar, is everybody familiar with 1910-147 Appendix A, the typical minimum lockout procedure? Everyone in the United States who manufactures products for a living has an obligation under the federal law to develop a lockout tagout strategy. I have yet, like I said, to have a client have one of these in advance of meeting me for the first time. I cannot explain why OSHA regulations get such short shrift and why they're ignored as much as they are, but it's profoundly imprudent to ignore OSHA, considering that OSHA is the law of the land. So, in this case, you're now an engineer, you've done your level best dutifully to come up with a risk assessment. Yeah, it's likely we can avoid it. If he does get hit, it won't be that bad, etc. And you've chosen safeguards based upon that risk assessment, and that person gets hurt anyway. Now the burden is back on you. Okay? And largely, one of the first things the OSHA guy is going to request is, what was your lotto plan? And again, the right answer in that case is not, I don't know. For plaintiff's counsel, like I said, asked to see the risk assessment. It's a winning strategy, and I've proven it in 16 prior legal cases on both plaintiff and defense side. There's two different types of strategies here, of course. In the last three cases that I participated as an expert for the plaintiff, my work was largely responsible for 2 six-figure judgments and 1 settlement in an aggregate amount of 7 figures. Let me tell you why this is significant. And the insurance guys can speak to this, obviously. Insurance companies don't like to write big checks ever. And after an insurance company writes a big check, many times companies can't get reinsured. I've seen companies go bankrupt, involuntarily sold, or just voluntarily close up and go away. This is a serious matter. And again, not being mindful of the OSHA requirements and giving short shrift to that can lead to a disaster. On the defense side, I do have clients that come to me on a prophylactic basis. I call these the good guys. Companies come to me and say, you know, Vern, we'd like to examine our operation and see if we're operating safely, if we're doing things right. And in the last 5 years, I've had 10 of those clients. They didn't have an accident pending. They called me, again, up front to make sure they're doing the right thing. Now, if I get the other situation where defense counsel seeks me out long after, as they say in the parlance, the horse has left the barn, then you have to go back over and take a look at what you can credibly cobble together in terms of a risk assessment and try to bargain for your best deal. On the prophylactic side, though, it's a smart idea to shake down your facility and see if you are, and I hate to use this language, I know the OSHA guys hate to hear me say this, but OSHA-proof. You know, I make sure that you're OSHA-proof. And industry voluntary standards, again, be damned, it's all about who carries the badge. And in this country, still, the guy who carries the badge is either OSHA themselves or their state-appointed brethren, or in some cases, like Cook County, Dade County, certain county and municipal jurisdictions who take the OSHA code and they add more stuff to it. But that's law. Everything else, all the ANSI stuff, all the ISO stuff, all of that is industry voluntary, nice information to have, but if you're running a business and you're responsible, it's OSHA that matters. With that, I'll take any questions you might have.
And can all the attendees please type the passcode into the Q&A once again? Our first question is, if Mr. Albu had not bypassed the safety guarding but tripped the safety switch when crossing it, would the accident still have occurred?
The answer is yes, because if he would have tripped the safety switch, he still had to fix the machine, so he would have reset the safety switch and went back in. His accident occurred because of the unfortunate reality of pressing the wrong output. But no, precisely in that case, let's say he violated the safety perimeter and all the switches and everything were functional. He would then probably curse his bad luck and have to go back and reset everything. But he still had to go in front of that press with the Motorman Teach pendant in Teach to cycle the clamps to make the adjustments he had to make to correct the problem to get on with production. I cannot emphasize, this is the hardest thing I've had. One of my colleagues and I got into it a little bit this week because I've been so frustrated. This has nothing to do with safety fence. That absolutely has nothing to do with safety fence. Again, picture this cell in a plant in another country where they don't use safety fence, and there's a lot of those, by the way. It's not a safety fence issue at all. He had a teach pen in his hand. There were hazards that were not mitigated. He accidentally, and we all make mistakes, tired, late at night, second shift, what have you, he mashed the wrong output. That's what caused the accident. This preoccupation with the safety fence, to me, is very frustrating. But hopefully that answers the question. Yes, it still would have happened because after he recovered and he reset the safety fence and he cursed his bad luck, he would have put himself in front of the press, and that similar fatigue or whatever affected him that caused him to make a mistake, he would have made that same mistake and he'd been injured just as well.
Okay, the next question is, why are the two most common OSHA regulations not recognized or acknowledged by ISO?
That's a very good question. The ISO system operates apart and parallel to what we do in the U.S. I've sat in meetings and conferences, and I've discussed this with some of my international colleagues. They really, and I want to be careful. I want to pick and choose my words carefully here, and don't say anything too dramatic, but they, in many cases, view Lotto with contempt. They openly make jokes about the U.S. system. We are so backward, we're so tedious, we're so bollocks up with rules and regulations. I've heard every manner of different type of derogatory comment about OSHA. OSHA gets a bad beating internationally. So that's just a difference in culture and history. And certainly, let's face it, in other countries, the working man is not necessarily as protected as he is in the States. Here in this country, we all make jokes about the lawyers who advertise at 2 o'clock in the morning about injury accident victims. We all make jokes about that. But at the end of the day, that bottom-feeding type process keeps us the safest country in the world, still. And I'm quite proud of that. I have no problem with that. Now being a grandfather, well, before I had my own kids, but now I got grandkids. And I still eschew to the rule that I created in 1991, and that is the offspring rule. If you want to be safe in a plant, the way to be safe is to have no operation in any plant you run that you'd be uncomfortable having your daughter run. If you'd be uncomfortable having your daughter run it, then don't have it. I call it the offspring rule. So I can't explain the rest of the world except to say in their legal system, here in this country, every man has his day in court, but not so much the rest of the world. Question?
Okay, and do you see these regulations being recognized by ISO in the future?
Oh, hardly. I don't think so. In fact, right now, under collaborative robots, we are sprinting in the opposite direction. I've got 2 cases right now with collaborative robots, which means, what the term collaborative really means at the end of the day is that a man comes into contact with a machine in restricted space in some form of automatic mode. I've got 2 different cases currently where workers are too afraid to go back on the job. They're afraid of working side by side with a robot device, even though it may be low power, it may be torque limited, and all those nice things. But we in this country, we recognize mental pain and suffering. We've had some people who have already been injured slightly, but then once injured, they're very, very hesitant to want to go back into harm's way. And who can blame them? We're going to see a whole brave new world of those kind of problems, where the mental suffering, working side by side with a machine, and there's some glitch, some problem, something happened. And for those that are collaborative robot aficionados, these 2 cases have all happened in the last year, and they both happened to a company that's foreign-based, for lack of a better term, foreign-based, who brought this automation with them here to the States. So that's a whole brave new world under collaborative. We'll have people scared to death to go on the job because they don't want to work next to a machine that might incidentally cut and bruise them. Next question.
Okay, if a formal risk assessment was not created, what steps should be taken next?
All right, if you've not done, put this in context, a formal ISO risk assessment, there are other risk assessments that are available. Other individual application specialties have their own risk assessments. OSHA, in fact, has a risk assessment you can download and use. Historically, in my practice, I've used historically B1119 and B1120 and put together my own risk assessment. So current, formal risk assessment is still a good thing, just not a qualitative ISO risk assessment. That's a different matter altogether. If you take the OSHA risk assessment and follow their approach, the ISO people would say, well, that's overly restrictive, that's not as productive, that's more expensive, and so be it. That may all well be true, exactly. But no, risk assessment is still value. In AWS, we have a standard called D16.3, which is risk assessment for small parts arc welding. Well, that was written by the welding experts in the robot business specifically for the hazards that are associated with small parts robot arc welding. And I want to see more of that happen. But as far as risk assessment, yes, very valuable. But formal ISO risk assessment, that should give you pause. Next question.
And why would you say most routine accident cases rarely go to court in the U.S.?
Well, they go to court, they just don't go to verdict. they don't go to a judgment or a settlement. Everything I've researched, I went to Westlaw and I went to LexisNexis and I've tried to look up cases and so forth. It's because insurance attorneys sit in the deposition room and they watch the reaction. And I'm an engineer by training, both academically and by vocation. And engineers make very poor witnesses. We're typically very arrogant, very egotistical. We know everything about the technology, and we want to explain how much we know. That's really bad in a legal setting. You get an engineer on the stand, and he starts explaining. Then you find yourself, and this happens obviously at the deposition level. It doesn't have to actually go to trial. I've watched insurance attorneys start wringing their hands as they watch your engineer squirm and die, and leave the room to get fresh air, and then come back and say, "Can we go off the record? Well, let's go sidebar here for a minute. I think we need to talk," and then the settlement follows thereafter. So, from that perspective, none of these things go. You're not going to put this in front of, not in this country, not in a trial by jury situation, because the jury's going to see, gee, this guy, he thought this was a good idea. He can't explain why he thought it was a good idea. He can't document it, and he can't explain why he ignored OSHA. And OSHA is the law of the land. I mean, even the common layman can understand that concept. Here's OSHA, it's government, it's the law. So no attorney wants to bring a case in a trial like that. And like I said, I've had two cases where the jury's been seated. I kept thinking, all right, we're going to finally try one of these things. We're finally going to have my Perry Mason moment, okay? And it didn't happen. In both cases, it settled in the hallway, and I packed up the banker's boxes, I put the case away, and moved on. I did that with the Cameco case. When the underlying case settled, Cameco settled, when Wayne Trail settled, I didn't think twice about it. I packed up my files, put them in the banker's boxes, put them away, and thought I'd never see it again. It was only by a bizarre stroke of circumstance that this thing is even being discussed today in the webinar. It wouldn't even be here if Cameco hadn't made a business decision a couple years ago to fight the VSSR and then appeal it 3 times and then finally appeal it to the Supreme Court. If all those things hadn't happened, we wouldn't be having this webinar today because I would have nothing I can talk to specifically. I'd have all the cases that I've worked on, but I can't speak to specifically. Questions?
Okay, every state has a workers' compensation system. How does the ISO-OSHA mechanism interface or interplay with workers' compensation actions instead of going to trial in a state or federal court of competent jurisdiction?
It depends on the state. As many people on this line, I'm sure, are probably Michigan folks. We have California. If you look at some of the OSHA operations at a state level, Ohio had a state operation, and we disbanded that. I mean, first we didn't have it, then we had it, and then we did away with it. And we did away with it because legislatively, states can legislate any way they want. Now, Wisconsin, Michigan, Massachusetts, California, they're probably the most tedious of states. Those that are more loose, states like Georgia, et cetera, state legislature has taken a different view of worker safety. So the beauty of our federal system is that we have federal law, and then we have 50 states. And the 50 states interpret that as they see fit. And don't hold me to the exact number, but it's 30-plus states have equivalent state OSHA. In Michigan, they call it MIOSH. And for the Michigan folks that are on the line, as you well know, MIOSH is tougher than regular OSHA. California OSHA is a lot tougher than federal OSHA. And that might be a surprise to some people that are in a state that doesn't have a state operation. But actually, the state operations in the states that have it are typically, by my experience, a lot tougher than the federal OSHA. So that's the system we have. That's the kaleidoscope system we have. It might be a decision you might want to make when you move your business or you build a plant somewhere. You might want to take a look at if it has a state operation or not. But it's state by state, and it is what it is, and it's the beauty of our legal system. Question?
Okay, those are all the questions we have, so thank you so much for answering those.
Thank you.
In addition to being your best source for testifying and consulting experts, TASA also offers e-discovery and document management solutions, free interactive webinars, and research reports on expert witnesses, such as the Challenge History Report 2.0, the Professional Sanction Search, and the Expert Profile 360. I would like to take this opportunity to thank everyone for attending, and most especially Vernon Mangold for his time and effort in creating this presentation. If you would like to speak with Mr. Mangold, or if you would like to speak with a TASA representative regarding an expert witness for a case that you are working on, please contact TASA at 1-800-523-2319. Thank you all again for attending, and have a great day. This concludes our program for today.
Thank you.